a průběžně přijměte místa ještě a připojte se k nám. Já možná na úvod zmíním,
Just as a way of introduction, I will give you some housekeeping rules for this panel. It will be more focused on debate. First, we will hear introductory remarks by our three guests. I will introduce them shortly. Then there will be a debate, and after that, there will be time for your questions. So prepare them, and you are very much welcome to participate in the debate. Hello, my name is Lenka Kabrhelová. I will be the host of this block on this conference of Václav Havel Prize laureate. In this panel, we will talk about justice. What are the ways to justice in case of war conflicts? Can it be achieved? What are the mechanisms we have at our disposal, and what mechanisms are applied? How to prosecute violations of human rights, how to document it, how to record it, and how to bring to justice those who perpetrated these crimes. These are the topics of this block. So I would like to welcome Veronika Bílková, a professor of international law, who focuses on international law. She is the head of Center for International Law. Hello, welcome. Then we have Tomáš Holub, Bishop of Plzeň, the first military chaplain. Hello. Hello. And we also want to welcome Vladimír Dzuro, a former prosecutor of International Criminal Court for former Yugoslavia. Hello, welcome. So first of all, I would like to ask you for introductory remarks that you have prepared. Thank you for that. And then we will go to debate. So, Professor, you have the floor. Hello, good afternoon, ladies and gentlemen. It is a great honor for me to be here. First of all, I want to congratulate all the laureates, but it is bittersweet to congratulate laureates in this context. I would prefer to congratulate on something better, some better thing. I will speak very generally in my introductory remarks. I will mention 3 points that relate to the conflict in Ukraine, because I have spent a lot of time dealing with this, but they are very general, so they can relate to post-totalitarian situation. First point I want to mention, it is self-evident, but it is good to remind it. Any conflict, and the conflict that we can see in Ukraine, has an impact on society and its functioning. We are talking about crimes, and it's a good thing. Unfortunately, Ukraine is an example of this, as we heard in the introductory remarks. All of the different crimes were committed there, war, aggression, crimes against humanity. But war also destructs the country in many other aspects. Infrastructure is non-functional, schools are closed, healthcare is non-existent, people leave the country. And all these aspects keep changing the country, and it has an impact on the country. The society after war is not the same as it used to be before the war. That was the first thing. And this relates to the second point I want to mention. Coming to terms with the effects of war, during the war or after it, is a process that needs to take time. It takes a long time, it's time-consuming, it also requires funds and patience. We are talking about wheels of justice, and making them turn is very difficult. And I am a lawyer, and I want to mention that it's not just a legal process, and it's not just criminal process. Very often we focus on punishing the perpetrators. Yes, it is good to focus on the punishment. It's one of the parts of reconciliating with the past and with impacts of war and armed conflict. But if you want to make these wheels of justice turn, we need to think of other components. We must not forget other perpetrators. We must not forget the victims. We must not forget the rest of the society. To achieve justice takes or is composed of different components, not just the criminal repression. And the third point, I want to be optimistic, which I was not able to achieve in the first 2 points. I want to stress that today, fortunately or unfortunately, we have at our disposal as international community and different countries, we have different tools, instruments and institutions that allow us to come to terms with the effects of conflicts such as in Ukraine. We have International Criminal Court, international cooperation in penal matters. We also heard about truth commissions. In Czech Republic, we know lustration processes. There are different laws relating to this. So the whole transition process, transition from non-democratic country to a democratic one, or dealing with wars and conflicts, this process is very well established. But sometimes people think that if something is not able to be solved now, we need to find another solution, another institutions. But we shouldn't come to these hasty decisions. Before creating new institutions, we should think of what we have at our disposal at the moment and how to use it to the fullest. Thank you for your attention, and I will be very happy to answer your questions. Thank you.
Poprosím pana Holuba.
And now, Mr. Holub. Hello, good afternoon. Thank you for having me, and I want to congratulate the laureates. I want to say something similar to what the professor said. I thought that an international law professor would talk about legal matters, and I thought that I would have the opportunity to speak about transcendental things. But Professor also has talked about these transcendental aspects, and I will just try to expand on it. In my opinion, the fundamental questions we are having while we are talking about the second stage of this conflict, this means that the war will end and we will try to find new ways to move on. The thing is that the war doesn't stop with the moment where arms do not shoot anymore. The war ends when the society tries to deal with its effects. So when we come to the second stage, the stage of searching for justice, the retribution for what has been done, this will be a very important component of the whole process. In Europe, there is a tradition of Thomas Aquinas, who said that justice is the lowest level of love, and all the images about love towards others are false, and they only lead to new conflicts because they are not based on truth. And this is of utmost importance. From my own experience, I can tell you that how I lived through the conflict in Yugoslavia, where I worked as a chaplain, this experience showed me that there were attempts to create cooperation capacities without naming truthfully what had happened during the Second World War. But for these reasons, we have to ask questions where to go on next. But we are not only trying to find justice, we are trying to find peace. And in these situations, peace cannot be just a poetic term. Peace has other contours, other components. Peace is not just absence of war, lack of war, because lack of war is another situation that we know from the Cold War, and unfortunately, over the last several years that we thought were peaceful years, were in fact years where none of the actors was convinced that they could gain benefits by using war force to the detriment of others. But peace is a situation where there is a common understanding and common conviction that the good of others also benefits our own good, and that cooperation is a way that is more perspective, has more prospects than dominance. And I want to say that just putting justice in this framework means that justice has the right place. On one hand, without justice, we cannot talk about these more extensive aspects. But if we don't have this justice, we enter this vicious circle, tooth for tooth, eye for an eye, where we retaliate, and our retaliation is much more stronger than what we have suffered. So we should ask on how to apply justice in this whole context, aiming for peace.
A jako třetího poprosím
third speaker, and this is Vladimír Dzuro, who was the former investigator in former Yugoslavia. You have the floor. Good afternoon to Prague. I'm speaking to you from New York, and I hope you can hear me well. I am sorry I wasn't able to come to Prague in person, but I am really envious. I envy you the opportunity to speak in person. I have prepared a contribution, a written one, and I will read it out, but I promise that then I will just speak from the top of my head. First of all, I would like to thank the Václav Havel Library and its management for the invitation. I believe that we will find a connection between what happened in the former Yugoslavia at the end of the 20th century and what is happening in Europe right now. I must point out that my employer does not allow me to comment directly on the events in Ukraine, and my opinions here cannot be considered as those of the UN. If we go back to the beginning, the very first attempt to punish war crimes after the first century was the Leipzig trial. However, it ended in a complete fiasco. Most of the defendants were acquitted, and the main culprits were not even brought to trial. So the wheels of justice were set in motion only in 1945, after the end of the Second World War, when the Nuremberg and Tokyo tribunals were established. The creation of these two military tribunals was very complicated. It was the result of the London Charter, and the aim was to punish crimes committed by officials in Germany and Japan. However, this is why these tribunals were often called the victors' tribunals. With the outbreak of civil war in the former Yugoslavia and with reports of gross violations of the Geneva Conventions, the international community had to take action again. In 1922, an expert commission was sent to Yugoslavia, headed by the Polish politician Tadeusz Mazowiecki. The reports of this commission Commission were decisive in the adoption of Security Council Resolution 827 of the 25th of May in 1993. One of the key figures in the creation of the Tribunal for former Yugoslavia was Madeleine Albright. And to clarify the expectations prevailing among politicians at that time, I would like to quote Madeleine Albright and what she said before the tribunal. They said that there would never be indictees, and they said that there would never be any trials. And then they said there would never be any convictions and any sentencing. And at each part along the way, I would point out that they were wrong. And one of the reasons that I think that it is so important that this procedure is going forward is to show that they were all wrong. That the tribunal is very much a part of the international judicial system that is playing a very essential role, I think, in making sure that this individual guilt is assigned, that punishment is meted out, and that there can be reconciliation. I think that was the whole purpose behind having such a tribunal, so that there could be ultimately reconciliation of the various people that were innocent as part of this. Unquote. I think that the tribunal was a success in the end. It has completed all the cases, and it is considered the most successful institution that helped the creation of the International Criminal Court. In 1993, there was only a handful of living lawyers who had been directly involved in the Nuremberg and Tokyo tribunals. So the newly established Tribunal for former Yugoslavia was starting its work literally from scratch. Today, however, the situation is better. In the Czech Republic, too, we have a number of personalities with experience of investigating and trying war crimes. I would like to mention Dr. Janu, Dr. Hedličková, and Dr. Fremer, who worked as judges at the tribunals, and Dr. Richterová, a very successful prosecutor who is now working at the International Criminal Court. We also have experienced investigators who participated in trying war crimes. In order to successfully judge war crimes at any time, including today, you need two things: the political will and funding. International justice, unfortunately, is very expensive. Just as an example, the work of the Yugoslav Tribunal has cost the international community more than 50 billion crowns. It remains to be seen whether the international community is now not only able but also willing to find political consensus that is needed to try war crime on both sides of the current conflict in Eastern Europe. That is a question that I would like to raise by way of conclusion. Are we willing and are we able to find political consensus and provide finances for this? I think that today, given the situation that exists, the trials will be even more expensive than those we paid for crimes perpetrated in Yugoslavia. Thank you for your attention. Thank you to all of you for your introductory remarks. And I would like to start with what was maybe omitted at the beginning, which was the legal aspect. Please, Dr. Bílková, could you tell us at which stage the attempts to bring perpetrators of war crimes in Ukraine to justice is now? Okay, so you are getting back to what I said was not central, but of course is essential, and that is the legal aspect. We all know that the conflict is not over yet, and the justice can be obtained only after the conflict has been closed. However, to wait for collecting information until the war has ended wouldn't make sense. As we have heard in the previous panel, data were collected from the very first day of the conflict. And this preliminary data collection can be started very early on with investigation committees, with dedicated missions. Then the prosecution is started by national authorities or by international ones. Again, as we have heard at the beginning, the situation in Ukraine or the investigation of the situation in Ukraine is the responsibility of the International Criminal Court. There are not yet concrete convictions or concrete charges, but the situation has been opened. The investigations have been started in Ukraine in order to identify culprits and come up with first warrants. So this is the stage we are at right now. We can say that it is a very good situation compared to the situation at the beginning of the conflict in Yugoslavia, because now the procedures can start immediately. So this is the international level. Then there is the domestic level. Investigations, national investigations have been taking place in a number of countries. Of course, first of all, there is Ukraine, and it is very active from the very first day of the days of the conflict. They have a website of the public prosecutor in Ukraine, and there are thousands of testimonies. It is about war crimes, crimes against humanity, but also about crimes in general. So criminal procedures or steps leading to criminal procedures have been undertaken in a number of countries, including the Czech Republic. You have also read about this in Czech media. For example, we have taken part in this based on the fact that we have refugees from Ukraine coming to the country and bringing evidence. So you also mentioned that you took part in one of these OBSE missions in Ukraine. Can you mention the places you visited and the results of your mission? There were two missions, in fact. First of them was held by OBSE, and the first of them was organized by OSCE, and the crucial thing is to have a group of experts who very quickly, during 3 weeks, prepare a report on a given situation. This one considered the respect or the violation of international humanitarian law in Ukraine. Altogether, there were 2 reports covering the period from the 24th of February to the end of June. So the first mission didn't involve a journey to Ukraine because that was not possible, but the second mission did involve it because this provided us with extra information and also gave us more legitimacy. And we were able to show the validity of our observations to Russia. We couldn't, of course, visit all places which were visited by the UN mission, but we visited Kyiv, Bucha, and other places, including Irpin. We spoke to people from these cities and towns and from other regions in Ukraine, which was very important for our reports. Can you mention the type or the nature of crimes you dealt with? Well, it would be shorter to name the crimes we didn't encounter. I am generally quite reluctant to speak in general terms, but here we can say that in Ukraine, specifically on the side of Russia, they perpetrated crimes against humanity, including the most serious crimes. This included manslaughter, targeted manslaughter of civilians, torture of war prisoners, raping women and men, forced disappearances, looting. Really, the list is very long, so it's hard to say what wasn't done in Ukraine, unfortunately. Okay, can you say, when you were there, what did you need to take into account when investigating? Maybe the most important thing for us, not only regarding the information we obtained there, but also information in general, was being objective, remaining objective, because an information war is raging on both sides. So it was important for us to reflect the reality faithfully, to have evidence that is based on facts. And when describing the events, we always looked for more sources. So we would never trust a single person, a single resource, but would always fact-check with other sources, so that we have at least two independent sources that confirm an event. That was difficult given our time framework. I imagine that Vladimír Dzura also has experience in this. You were part of the Tribunal for former Yugoslavia from the very end. Maybe you have similar experience. What was the crucial thing for you? What did you take into account?
Thank you for this question. I think in this aspect, this is a situation that I can comment on. I would like to thank Professor for her work in this mission. From my experience, I had experience with Mr. Mazowiecki. They presented reports to the UN, and these reports were basis for our work. The investigation started in 1994, then in 1995, it was brought before the tribunal. I will try to describe this to lay people that fortunately don't have any problem with this investigation. When there is a crime committed at Wenceslas Square, when somebody is killed in Wenceslas Square, there is a whole system in the Czech Republic. We've got the state prosecutor, we have law enforcement, and everybody knows where Václavské náměstí, Wenceslas Square, is located. But when you work with international organization, you have very limited knowledge of the territory. It's either limited or non-existent. I spent 1 year in Sarajevo, where I worked for UNPROFOR. So I had some knowledge about the terrain, but it was still limited. And for this reason, the results of the commission were essential for us. We were charged with investigation of crimes in Croatia. So the report helped us to gain information about what types of crimes should we investigate. We didn't know the issue. We were all prosecutors or investigators. We were very good at what we did, but we had very limited knowledge of the situation that happened there in Croatia and in Yugoslavia. And NGOs also helped us. I call them enthusiasts. They have direct access to the place where the crime was committed. In this case, it was war crimes. And these NGOs are able to document what happened there. I will give you an example. We investigated in Ovčara, in a farm in Ovčara, where 265 patients from Vukovar hospital were killed. The grave was found in 1992, and we were only able to travel there in 1996, so we didn't have the access to the scene of crime, the crime scene, for 4 years. So this has a huge impact on the evidence that can be used during the proceedings. And these enthusiasts, these NGOs that talk to the families of the victims, gained this testimony and gave them to us, and we were able to use them in our work. But there is always the other part of the case. These enthusiasts are not experts on this work, on this type of work. They talk to people and they find out that something had happened. And in their report, they write as if it was first-hand knowledge, if it was something that they lived on their own. And in many cases, we came to the conclusion that we mined the information from the reports drawn up by NGOs. Then we went to former Yugoslavia to hear out the direct witnesses. And then we found out that they just heard about what happened. They didn't see it with their own eyes. They heard it in refugee camps, and based on these informations, they talked about it with the NGOs. So from the evidence base, from the point of view of the evidence that can be used at court, this had almost no information value. So we had to find witnesses, first-hand witnesses. But this doesn't lower the value of the work of these enthusiasts. These people who work in the field, and they are willing and able to document the evidence and then to pass it on to law enforcement and investigation authorities with the relevant jurisdiction. And let me conclude by saying that what we did in the 90s, and there is a difference between what we did in the 90s and current situation. There has been a huge technology development, and we can see the war in real time. We can see what is happening in different corners of the world in real time. But also there is a second side of these technologies. These technologies can be manipulated. This means that from the procedural point of view, and Professor can agree, that what we can see in the TV may not be always used at the courtroom. They may be two separate things. We need to obtain the source of the information. When somebody says something on Facebook, on Twitter, it's good for the media, but at court it has very limited value. We need to get into contact with the people, and we need to have the mobile phones or the cameras where these documents, where these recordings were made. And only these recordings can be used at court. And only this type of evidence can be used. Thank you. So we can see the difference from the time 30 years ago. But let me come back to the role of NGOs. We have had representatives of 5 AM coalition that gathers documentation on violation of human rights and law in Ukraine. We heard that it's a very difficult job, but it's still essential. NGO members were there in the field from the very beginning, where no other investigators could come. But Mrs. Bílková, I have a question for you. What is the importance of using the same mechanisms and methods that the NGOs use so that the evidence can be used at the courtroom? Is it important? If you're relating to me to the investigation group, we are in a slightly different group than Mr. Dzuro. We were not and we are not a criminal entity. We did not gain evidence that could be used before court. What we did was preliminary recognition of the terrain, so we monitored general trends. Our reports used statistics, probability, and general trends. We describe that with high level of probability, some types of crimes were committed, but we are unable to identify the perpetrators. That's impossible to do within 3 weeks. So our job is very similar to what NGOs did. We do some preliminary collection of evidence that can be used as a basis for evaluating the situation on the political level. For example, while adopting sanctions. To adopt sanctions, you need some basic evidence on crimes that are being committed. So we are able to provide these preliminary evidence, but this evidence cannot be used in criminal proceedings. That's the role of investigators, as Mr. Dzuro is. But these NGOs can play a role in the preliminary and both post-procedural situations. If they are trained well, if they use methodology, and we have heard that there were some guidelines for collecting evidence. All these organizations can help in collecting evidence that could be used before courts. But there's one more risk, apart from those that Mr. Dzuro has mentioned. If there are too many actors in terrain, which was the case at the beginning of the conflict in Ukraine, there were some NGOs, both national and international, many enthusiasts, and all these actors started to collect evidence spontaneously. It is quite good, but there are some drawbacks to this. If there is a victim of rape, and there are 10 people who ask this victim to describe the rape, this could lead to trauma in these witnesses, and they will be not willing to explain what happened. So when there is a prosecutor from court and asks for this testimony, the witness doesn't want to repeat it for the 11th time. So yes, it is necessary to be present from the beginning, but the interests of the victims need to be taken into account. Now, Mr. Holub, I want to talk about your experience as a military chaplain. You have already mentioned it. You were in former Yugoslavia and Iraq and Afghanistan. My question is, when we speak about the situation before the war, how the soldiers see the borders of their responsibility. First, let me react on what has been said. From the point of view of a military chaplain, who lives all the good and bad things of a soldier, we are there to listen to the soldiers. This is our primary position. And we perceive the reality subjectively, but we still need to have a distance. And the prosecutors needs to have even more distance from the subjective situation. And from this point of view, I can say that we have heard that the soldiers very often say that this searching for evidence and investigation are nothing compared to risking our own life. So this creates a type of tension. And in my opinion, it's up to the military management and other responsible people in NGOs who have a specific role, and also on the level of investigating bodies and tribunals. All these actors should try to achieve one goal, one objective. Because if these activities do not go hand in hand and have one main goal, that means to reconcile and to find a solution, well, then there are huge risks if this doesn't happen. The word devil comes from diablos, which means to divide, to discriminate. Evil is able to divide society. So these were the ideas that I had when I was listening to my colleagues. But going one step back. Let me start saying something different. What Germany lived through after the Second World War is that it defined a soldier as a citizen wearing a uniform. So soldiers were considered as citizens with the trauma of the Second World War in Germany. And what we can see nowadays, and what becomes more openly published from the German academia and other circles, is that the definition of a soldier is that soldier is someone who is not ready to see and live through the atrocities of war. Because the pressure from different circumstances is so big that the soldiers are not willing to live through the atrocities of war. And there are debates about the borders on between the situation where soldiers are willing and able to stop the evil on one hand, and on the other hand the soldiers should not lose their faith in democratic values and the values of freedom. And there's this tension between these two aspects. And from this tension leads to the fact that these soldiers see their friends dying, and this leads them to a thin ice. And on this thin ice, the soldiers should do some actions that has deterring effect on the other side of the conflict. And this is a risk for armies in democratic countries, not mentioning Abu Ghraib in Iraq, which was a great example of this. And then on the hand we have frustration. And the typology of people entering the army is specific to some extent. We have to admit it. We know that a humanist loving flowers will never enter an army. This will never happen. And this needs to be processed. We can see that society wants to have effective defense. We could see this during the first days of war in Ukraine. I am a theoretical viewer. The Ukrainian army was able to defend Hostomel airport, which had a great symbolism for the whole war. We saw they were really heroes. So not losing faith is very, very difficult, and we can see these risks. And you are speaking about armies of democratic states. Now we are speaking about Russian army. That means an army of authoritarian and totalitarian regime, which is based on different principles, where soldiers are not encouraged to respect some basic principles.
Jsem pochopil, proč i v té etice celého západu je, že
Well, what I can understand that in the eyes of the Western countries, war is the last resort, because during war we see the worst aspects of everyone. Okay, let us get back to the criminal law and these legal aspects. Do you think that there is the same option for Ukraine as you took part in, Mr. Dzuro, with an international tribunal, as was the case for former Yugoslavia? And Dr. Bílková, what are the options now in play? Well, options have been put forward from the very start, from February, but a possible international tribunal, as was the case for Yugoslavia and for Rwanda, these were set up when there was no international criminal court. Today, this type of crimes can be prosecuted and is prosecuted by the International Criminal Court. So there is no need to set another tribunal that would just do the same work. When we consider setting up a dedicated tribunal for Ukraine, we are speaking about a special institution which would try the crime of aggression, meaning initiating the conflict against another sovereign country, which of course was the case here. The International Criminal Court can also try this, but with the permission of both the aggressor and the victim country. And as we can imagine, in this case, Russia wouldn't agree with such a procedure. So there are ideas about setting up an international tribunal that would deal with this crime of aggression so that it can catch up with what we cannot do in the International Criminal Court. However, I am a little bit skeptical. The fact that this crime cannot be tried by the International Criminal Court doesn't mean that such a crime is unpunishable. You can prosecute this crime at the level of states who have the universal jurisdiction. So this crime is already being examined at different national levels. Such countries are, for example, Latvia or Poland. So here this can be tried, but it cannot include the big three. The president of the country in question, the Minister of Foreign Affairs, and the prosecutor of this country, including Mr. Lavrov and Vladimir Putin in this case. So while these people are in office, they cannot be brought to court in other countries, in Poland, in Ukraine, or elsewhere, not even in absence. However, if maybe this special tribunal for Ukraine is set up, some claim that this could be avoided. I am, however, skeptical. I think that we would establish another institution which would be very costly. Its functioning would be very complicated, and in the end it would do what is already done by Latvia, Poland, or by Ukrainian national courts. You said that the tribunal for former Yugoslavia was one of the most successful ones in the history. So do you think that it helped bring about justice, that it really led to leveling or to reconciliation? Well, the question is complicated, and so will be the answer. We need to bear in mind two different aspects. The first one is as follows. Has the tribunal helped to bring about democracy in this country? I think so. Because without the tribunal, which addressed war crimes in this area, people would remain in important offices and would dominate the political and military scene in Yugoslavia, in former Yugoslavia, in Serbia and elsewhere. Then there is the second aspect, the aspect of ordinary lives. I always mention this during my talks to public. Just imagine that you are living in an ordinary village, you are watching the TV with your family, with your spouse and your kids. Then someone kicks into your living room, the military enters your house, rapes your spouse and sets your house on fire. You have nothing left. Your meaning of life disappears. You weren't involved in this war conflict, and then, from one moment to another, you have nothing left. Then, 10 years or 15 years later, when you get out of detention centers or refugee centers, somewhere far away in the Netherlands or elsewhere, there is a tribunal that tries the perpetrators of these crimes, but not necessarily those who actually committed the crimes in person. Will you consider this enough? Will you see this as justice being done? This question is very important because as long as you are not personally involved in what happened in the former Yugoslavia, you might think that the war is over. Everyone can hold hands together and be happy. But that's not the case. There are big blows in people's minds. And to give you an example, here in the Czech Republic, let's just consider the situation in Sudetenland after the Second World War. A lot of time, it has been quite some time ago now, but still it has such a big impact on our mindsets and on the political atmosphere in the Czech Republic. Although that happened many more years ago than what happened in the former Yugoslavia. So we cannot expect reconciliation after such a short time. Of course, the situation is getting better. The new generations without this direct experience with the war crimes perpetrated, these generations are doing better, but there is no immediate reconciliation. So when we try to promote unity and brotherhood, as was the case in the former Yugoslavia, it is a very complex thing. I am sure that my colleague Mr. Holub has seen the situation in Yugoslavia. It was as follows. They promoted brotherhood and unity. They had Tito, the dictator, who knew about the issues within the society. And he wanted to unify the society. So, hence this slogan, brotherhood and unity. he started claiming that the brothers of yesterday are now enemies. This was such a big change. What happened was that they changed the word for Serbian by Cherbian, and Croatian became Ustašov. So it was not Croatians and Serbians, but it was Četnici and Ustašové. So this was a newspeak, basically. During this conflict, symbols were changed to persuade people that these weren't brothers, these weren't Serbians or Serbs, but these were Četník. So there was a substitution of terms supposed to explain why they should fight now. So the reconciliation needs to take place in the heads of people. And it is very important, but we cannot expect it to take place quickly. This provides a good parallel to the case of Ukraine and Russia, because these are two countries that used to have good relationships, and now they call each other nazists and so on. I see, Mr. Holub, that you would like to say something, and my question to you is quite similar. When we speak about justice and the direct experience from Yugoslavia, maybe justice doesn't really provide consolation to an ordinary person. So then how do we obtain consolation? Thank you to Mr. Dzura for what you have said. I completely agree. I would like to repeat what I already said. Conditio sine qua non, or the effort at bringing about justice, is the conditio sine qua non, the major condition for everything else. We cannot simply try to forget what happened and start again from scratch. My spiritual experience tells me that we cannot forget what had happened. We need to identify the evil and call it evil, then punish it in front of justice. But then there is a next step, a spiritual step, which involves reconciliation and pardon. When John Paul II came to Zagreb, he said, please forgive and pray for forgiveness. At the time, I was struck by those words, and I didn't really believe my Pope. I thought it was hypocrisy, but later on I understood that when a conflict appears, there are different stages, and you cannot skip stages. But the ultimate stage involves individual people who need to seek inner willingness to forgive and to pray for forgiveness. Otherwise, we would get back to that vicious circle.
Možná něčem maličko panu Dzurovi oponoval nebo doplnil. Já se domnívám, že to...
In some points, maybe I would slightly disagree with Mr. Dzuro. What I have learned in Yugoslavia was that these two different labels for Croats and Serbs were not really accepted. Everyone felt as brothers, and when they had memorials for the dead, these were always called brothers. But at one point, everyone realized what happened, how much blood was shed. And I think a moment will come when we will maybe also forget how difficult the conflict had been. In Sudetenland, I can see villages that forgave and where the situation is getting better, or others where they didn't forgive, and these communities are lost. Mrs. Bílková, we are speaking about justice, about the culprits being brought to justice, about punishment, and I am about to ask you a very difficult question. Can you estimate the time it will take to try these? No, we cannot estimate that. We cannot even imagine the dimensions of the ongoing conflict. No. And in order to react on what was said, I will slightly disagree. I am always skeptical to the dichotomies, legal, illegal, good, bad, hopeful, hopeless, works well, doesn't work. We're speaking about this reconciliation, about this forgiveness, and if this happens, everyone will be fine. I think this is a little bit oversimplified and naive. When something happens, we bear it with ourselves, we keep it in our minds, we will never forget. This holds for any nation, any people, any event. You cannot imagine forgetting such a major event. You can undertake steps to help cope with this or alleviate the situation. And of course, legal actions are the most simple. They require money and patience, but they are subject to simple rules. Everything is written on paper, we know what the rules are and how to interpret them. But then there are more complicated processes. Those that are interpreted differently by different people. What is justice, actually? Different people see it in different ways. Different people see reconciliation in different ways. We can ask this question in the context of Ukraine, but also in the Czech Republic. If we ask ourselves if we have come to terms with the communist era, I guess that people will disagree here in this room. We have different ideas of how reconciliation can be obtained, of what it means to come to terms with something. So this, I think, will also apply to the Ukrainian conflict. I promise to the audience to also have the opportunity to ask questions, so please just wait for the microphone before you ask it, but the floor is yours.
Děkujeme.
I'm very sorry. My question is expert, technical, but I have to ask it. As far as tribunals are concerned, they were established based on the UN Charter, and they gave the Security Council some basic competence for managing the activity of these tribunals. The ICC was created based on Rome status. So you can imagine that during the first case, you can imagine that Russia will play its role as the permanent member of Security Council. The US also have their own problem with ICC. They are not a party to this ICC. So can you see a problem? Could there be maybe conflict between these institutions? You know, on one hand we have ICC based on the Rome Charter, then we have the UN Charter. So these are questions to both Mr. Dzuro and Mrs. Bílková. I think that the professor will be better in describing this and answering this. Ask me this next year in November and I will give you my opinion. Yes, I've got a lot of employers, but I don't have to be loyal to each of them. So I will just speak briefly. We have International Criminal Code for Rwanda and Yugoslavia in the 90s. They were created based on the Charter of UN Security Council. And then by the end of 1990s, the permanent ICC was established. For the new tribunal for Ukraine, potentially, it was considered to be created based on the resolution of Security Council of the UN. But, you know, it's unimaginable. And Russia will veto this step. The conflict is not here, and the reason is very simple, because there are not so many international tribunals. We have only the ICC based on, established by the UN Charter. So there are no ad hoc tribunals. Should another tribunal be established, we would see what its form should be. But there is no will to create a new tribunal through the Security Council. And we couldn't see this will many years before this war in Ukraine. Mr. Žantovský, I have just one observation. I want to talk about the doubts that were expressed by Professor Bílková. We need to see this issue from two different levels, from two different perspectives. We are animals endowed with memory, so we cannot forget traumatic situations like this, no matter what we do. But on the other hand, on the other level, we are moral creatures, and at least we have a chance to achieve transcendence. And on the transcendent level, we should be able to forgive, even though we are unable to forget. Then we have a question in the audience. Lady in black, in the back.
Dobrý den, Kristina Šanok.
Hello, Kristina Šanok, representative of Belarusian and secretary of Světlana Cichanovská office. Today we have heard like terms as crimes against humanity, universal jurisdiction, and please allow me to be voice of 10 victims from Belarus that live in the Czech Republic thanks to health program at Medevac. They know where the perpetrators in Belarus. In one case, we tried to contact law enforcement in the Czech Republic and try to use the tools of universal jurisdiction. However, the case was not continued, and one of the reasons was why there was no proceedings was that allegedly these people can use Belarusian tools and Belarusian legal system. So these victims had no other option than to use Belarusian legal system. In the meantime, the UN presented a report saying that Belarus that there is no law in Belarus and Belarusia, and then they cannot use. So my question is there a lack of political will or failure of the system, or both? Maybe you can give us some recommendation for these Belarusian victims that live here in the Czech Republic and are here to stay because they received international protection. What steps should they take in order to use these newly created mechanisms? I know that the Czech Republic is very active in drawing up methodologies, and in case of crimes against humanity, the methodologies would be the same both in Ukraine and Belarus. It was quite a specific question. I don't know if you have worked on this case, Ms. Bílková. I don't know this concrete case, and it's very difficult to comment on a case where you have no information and the only source of information is you. So I don't dare assess this or evaluate this. You have only time for one last question. The gentleman in blue shirt. Thank you, Jan Janagl. I have two short comments. There were comments on Sudetenland. It was genocide, and reconciliation is not possible if we don't call it the name that it is, and if we don't investigate it, as Tomáš Holub said. And the second comment, do you agree that what is going on in Ukraine is a great chance moral challenge for the whole humanity to change its way of living, because prosperity destructs human and future if it achieves a level where people lose their nature and natural aspect. Then we have another question here. Please ask your questions and we will try to answer them in summary. So please be brief and ask real questions. My name is Jaroslava Vránová. Hello to New York. To Mr. Dzuro, I have a question. You mentioned the establishment of international tribunal in former Yugoslavia. You said that it was successful because there was political will and funding. Do you think that this was based on London Charter that gave the recommendation to the UN? Do you think that this decision was taken based on this? And then we have another question. Hello, I have a question to Mr. Dzuro. China is not a member, contracting party to ICC. Does this mean that if China does not recognize the authority of this court, does this mean that the occupation of Tibet and other crimes perpetrated by China in Chinese region will never be punished? Or is there a chance to punish these crimes against Tibet? Thank you. We are going a little bit further to our topic, that is justice in Ukraine. So, Mr. Dzuro, do you want to react? As for the first question, the London Charter does not have anything to do with the establishment of International Court for former Yugoslavia. The London Charter is relating to the Nuremberg and Tokyo processes. The Yugoslavia court was established based on UN Charter. Maybe Professor can tell us it was section 7 of the Charter, if I remember correctly. So the International Court for Yugoslavia was established based on the decision of Security Council. 5 of those members agreed to its establishment. When we look back to 1992 or 1993, Ms. Albright was the permanent representative of the US to the UN. Soviet Union disintegrated back then. Eastern Europe was in its way of democratization. It was a unique situation, and in my humble opinion, it was possible to establish the International Court thanks to these circumstances. And second question, I am very sorry, I cannot comment on this. I have my own opinion, but I cannot comment on this due to professional reasons. I work with the UN at the moment, and I have very limited possibilities to comment. I'm very sorry for that. I know it doesn't look good. You know, why am I here? But I'm very sorry, I cannot comment on this. Mr. Hope, Mrs. Bílková, do you want to react on the questions? I want to say that situations as tragic as the one in Ukraine, we can hear apocalyptic views saying that it's a challenge by God. In my opinion, this is a challenge, and we should be close to the people who are suffering. And these moralizing dimensions should not be a priority at the moment. I want to end on an optimistic note. I see this crisis as a challenge. We hear voices saying about the crisis of international community or international law. But in my opinion, there were never so many countries that were protecting international law or applying it. We are now enforcing norms that have been challenged so far. You know, we set the standard so high, and we should hold on to this, and I think it's a good message for humanity. Thank you very much. Veronika Bílková, Tomáš Ulf, Vladimír Dzurov, thank you very much for participating in our debate. Thank you for the time. Thank Václav Havel Library. We also thank the host as well. Thank you. Thank you. It was very nice. I appreciate it.